Do you want to know how long does a no contact order last in Washington state? Are you interested in this area of the law? Are you dealing with a no contact order? Well, if you want to know the answer to that question, stay tuned because this is the video for you. My name is Lance Fryrear. I'm a defense attorney in Linwood, Washington. I have a law firm that's been defending people charged with crimes for more than 20 years. And we often get the question, how long is the no contact order going to last? When can I go home? Or when can my loved one come home if I'm the alleged victim? Well, I'm going to answer that. First, if you find this video useful, please like and please subscribe. More people will get the information they need. So just jumping right into it. What do I mean by no contact order? So for purposes of this video, I mean a criminal no contact order. There are civil no contact orders where someone gets a protection order, and that really doesn't apply here because whoever got the civil order could probably go in and ask to have it removed. And a civil order has typically a known period of expiration. The standard period a civil order exists is 1 year. It can be longer, but that's the standard period. On a criminal case, however, it's a lot more indefinite feeling and a lot more disruptive oftentimes. So for the typical criminal order, what's happened is that somebody's been arrested, called the defendant, and they're typically charged with a crime. And that no contact order is going to typically be entered at an arraignment. And that's if you're charged right away. There's a complicated situation. We have other videos on it where if you're arrested and not charged, then you're going to have an order that gets issued at your first appearance after arrest, usually the next day. And typically that order is only good for the most part for about 3 days. So you need to look at your court paperwork to see when it expires. So if you're in that situation, make sure to call an attorney or call us. But on a misdemeanor type charge where you're charged right away, at the arraignment, typically the court's going to issue a no contact order. And nowadays, what most courts are doing is they're putting in an expiration date of 5 years later. And we get asked all the time, oh my God, it's going to last 5 years. Is it really going to last 5 years? And I can say in almost all situations, that answer is no. What's going on is that's a pretrial no contact order. And you have to read the order. It says, what's allowed and what's not allowed. Typically, it's going to exclude the defendant from the home, from the workplace or school of the alleged victim. There's no contact with the alleged victim, no third-party contact, no surveillance, on and on and on. And you have to pay attention to it because violating that's a crime. But in some courts, they'll put like a 1 year on it or a 2 year or 90 days even. You don't see that very often. But basically, the court is just putting a date on there in their head to be safe because they don't want the order to expire while the criminal case is going on. If they put like it on there for 60 days, only that it expires in 60 days, and the case is still going on in 90 days, well, the order would expire and probably no one would notice because of how busy the system is. And the whole reason why the court puts a no contact order on to begin with is to sort of separate the parties and to protect the alleged victim, regardless of what the alleged victim wants typically. And again, we've got other videos. We've got one about, ways to try to get a no contact order dropped. We'll link to it right here. So how long is it going to last? Don't freak out if it says 5 years or 4 years or whatever. It doesn't mean that's how long it's necessarily going to last. Typically speaking, a no contact order will be addressed at the resolution of a case, or it could be addressed during the case, depending on what goes on with the case. So, how long does the order last? It depends on if the judge is willing to drop the no contact order pre-trial, or if the judge is willing to drop the no contact order at the end of the case. Now, your defense attorney and the prosecutor will have positions to take on that, and whoever the protected party is will also have a position to take on that. For the most part, for purposes of this video, I'm thinking about a situation where the alleged victim in a misdemeanor assault is not wanting the no contact order to exist. In many, many cases, the alleged victim tells the court or tells the domestic violence advocate, I do not want the order to exist. And The advocate will communicate that to the prosecutor. The prosecutor says, thank you for telling me. I think you need protection. Our position is we want the order to exist as the prosecutor. And the judge almost always will issue the no contact order at arraignment. Again, because the judge wants to protect the alleged victim. The judge wants to protect his or herself if something goes wrong. Lots of reasons why that order gets put in place. So that's the case I'm thinking about. So how long is it going to last? Well, if the defendant does some things to help change the defendant's position, some educational classes, some anger management, alcohol, or whatever your attorney tells you to do, and then the alleged victim goes and tells the court, hey, I'd like a hearing to address the order, then there's a chance that the court might terminate the order early. It depends on the nature of the court, the nature of the prosecutor, the nature of the advocate, the nature of the particular judge. It depends on the defendant's past history. It depends on what the alleged victim sounds like in court. There's a whole lot of it depends. But the reason why it's important that a defendant does something to change their position is the common question of a judge is going to be, well, what is different today, a month later, 6 weeks, 2 months later after the arraignment? What is different today than when I originally issued this order? And if the defendant's standing over here going, nothing's different, and the victim's standing over here saying, I just really want the defendant home, the judge is going to say, well, nothing's changed. So there's no basis for me to make a change in my decision. Now, however, if the defendant's done some things, well, the defendant's done 2 anger management classes and a DV victims panel, is enrolled in DVMRT treatment, and the alleged victim can say, Your Honor, I've safety planned with the victim's advocate. Here it's been 2 months, and I only want you to issue a no hostile contact order. If all those things line up just right, the judge might terminate the order early, and so that no contact order might only last through pretrial, through a certain number of pretrials. If that hasn't happened, and the judge might say, well, it's too soon, I'm still going to leave it in place, we can address it later, right? Sometimes the alleged victim can bring another motion, right? The judge will leave that door open. And sometimes it finally gets addressed at resolution of the case. And oftentimes, if the defense attorney and the prosecutor work together and come to a resolution, oftentimes the prosecutor might agree to withdraw their objection to removing the order. Sometimes the prosecutor will dismiss a case. If the case is dismissed, the order has to go away out of the criminal case. There's no longer a case to maintain it. And sometimes there'll still be a fight about it at the end, but it's safest if there's an agreement between the prosecutor and the defense as part of the resolution of the case that the order should be terminated. In felonies, I've seen some really bad things where orders can go on for years, right, without the consent of the alleged victim, right? The longest period of time that an order can go on in a criminal case is as long as there's jurisdiction. So for domestic violence cases, the longest jurisdiction would be basically, with some exceptions, think about it as 5 years after resolution. If there's warrants and things in there that could hold jurisdiction, it could go on for longer. But the court typically, right now in 2022, their jurisdiction on a non-felony domestic violence case is a maximum of 5 years. That would be that way it would last. In my 20 years of doing this, I've never seen that, though, in any of our cases. So how long is it going to last? It's going to last typically until the case is over. If things go well, they might be able to be removed earlier. Don't count on that because it's very difficult and sometimes it's counterproductive. If that order gets removed pre-trial, while it may be what everyone wants, it does put 2 parties back together who've been in a stressful situation. And while us attorneys want to trust our clients, I can say that some things are beyond the control of the defendant or the alleged victim. More disputes can happen. There can be more problems. So sometimes it's counterproductive to have that order terminated early. Although your attorney, if that's what you've told your attorney you want to try to accomplish, then that's what the attorney typically will try to do. So I hope you found this video helpful. It's a bit of it depends, but at least I can tell you, don't worry about the 5-year thing in the order, that type of stuff. And if you found this helpful, really would help out the public if you would like and subscribe. More people will get to see it. And finally, if you're in the situation, if you're an alleged victim or you're a defendant and you have some questions, if you think you might need some legal help, you can give my office a call. Again, we've been doing this for more than 20 years. If it makes sense, we'll set you an appointment. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.